General undercover and the General Neutral Counsel undercover against the Jamaican Bar Association.
Mr. Wood, have you negotiated an extra period of time?
Yes, my lord. Certainly the Attorney General has agreed that I can take off an extra 5 minutes of their reply time, and I don't think my friends have any objection.
And you've discussed it with Mr. Mahfood, have you?
Yeah.
Okay.
All right, well, 5 minutes. But just before we do that, we thank you for the note on grey listing. I did also, however, get a note from the Bar Association, the respondent's side, saying they hadn't been shown it in advance as I requested, and it's not an agreed note. I'd be grateful if it could be discussed and agreed if possible, or at any rate if the respondents have some specific objection to its contents to let us know what that is.
If I can speak for the General Legal Counsel as a competent authority, that certainly represents our understanding of the position.
Yes.
And that this issue has been delayed because of the rulings of the court that are awaited, yes. And they have given until February.
Well, plainly, the note would be helpful if an agreed form of it is available.
We will consult with the others.
The board would obviously not be happy to proceed on the basis of an unagreed note, and will just otherwise have to do the best it can with the existing materials. Yes.
My lord, in the 5 minutes allowed to me, I think it would be remiss if I let pass a few comments on proportionality.
Oh, yes.
And the objective of this system. I adopt those parts of the respondents, the appellant's case that deals with proportionality and the case law that we have set out. I want to emphasize, my lord, that when this regime was extended to the legal profession by the amendments to the law in 2013, it was accompanied by a document called the National Security Policy, which is referred to in the affidavit of Mr. Robin Sykes, page 1325 of the bundle, running from paragraphs 29 to 32. Your Lordship should not leave this case simply on the understanding that this is a FATF measure being implemented.
Sorry, what sort of measure?
That it is a measure of the FATF that is being implemented. The National Security Policy, which is in your bundle, traces a dire situation of a country in the grip of organized crime, beset by drug trafficking, trafficking in guns, extortion, and the vast wealth that flows into the country through the facilitators who are identified in the National Security Policy as including attorneys at law. It traces the attendant murder rate among the highest in the world at 7191 of your Lordship's bundle. The equivalent, they say, of Jamaica having a 9/11 event every week. It traces the attendant poverty that has resulted to the country over the last 30 years.
What was the page number you just gave us?
7191.
791.
7,191.
Thank you.
The document, the entire document or part of the document is found in your bundle commencing at 7172.
Thank you.
At 7196, it traces the resulting attendant poverty and destitution of the country. In addition to that, massive annual loss of life, where Jamaica has declined in per capita income as being from the top in the English-speaking Caribbean in 1974 to among the lowest by 2003. This is a growing monster, and the country has just ended one of numerous states of emergency this week.
I mean, this is up to 2003.
This is up to 2003. It identifies the business of crime at 7,202 and the facilitators as being a tier 1 threat. And by tier 1 threat, they identified that this is a threat to the existence of Jamaica as a democratic state. This is a looming tragedy. And it recommends among the measures to address it, and it may not succeed, but it recommends among the measures to address this at 7,207, the introduction of reporting requirements for non-financial institutions under the Proceeds of Crime Act. And this includes professionals such as lawyers and accountants and agencies such as the Real Estate Board, large-scale car dealers, and entertainment providers. In 2013, the regime was introduced for attorneys, accountants, real estate dealers, and casino operators. In my submission, the effect of striking down this regime makes the lawyer's office a safe haven, a safe harbor for the launderers. The effect of striking down this regime is that while others in the sector that is regulated have these onerous duties, the lawyer has no duty to report, even when he has knowledge or belief that the transaction is a money laundering transaction. Jamaica has a higher standard of reporting. We're not talking about suspicion. We're talking about facts which give rise to knowledge or belief. There's no duty to report. The quashing of Section 91A hollows out all monitoring. There's no power to inspect. And then the extension of the presumption of professional secrecy now gives everything in the lawyer's office the cloak of secrecy. As per the Canadian authority, professional secrecy that extends to the accounts, to the name of the client, everything is now cloaked. I submit that on any test of proportionality, on any application of that test, the decision of the Court of Appeal is wrong, and I urge that the decision of the full court be restored. Those are my submissions, my Lord.
Thank you.
Just before you sit down, is there any dispute that that national security policy for Jamaica of 2013, that lay behind the regime reform?
No, there is no dispute on that.
There's no dispute?
No, it was submitted to both courts as referred to in the affidavit.
Thank you.
Make it correctly, make it.
Those are my submissions.
I don't know, bring on.
Thank you, Mr. Wood.
No, I'm not using that.
Oh, you want to come here?
If I may, my Lord, in relation to the question that you just asked as to whether that national security policy, if there's any dispute that national security policy formed the basis behind the regime, it might have been a part of the documentation that was before the court, but certainly our understanding is that the regime is based on the FATF and CFATF recommendations, particularly recommendation 40, those 40 recommendations, as in all of the other jurisdictions to which the FATF recommendations apply. Thank you, my Lord.
Sorry, you've referred us to based on which recommendations?
I think it's recommendation 40. There are 40 recommendations that were put forward by FATF that would strengthen the system.
Is that in our bundle?
It is, my Lord. I am going to find it momentarily. It's only because, my Lord, you just asked the question and the answer that you gave.
Yes,
so I
want to just give us the page reference. That would be very helpful.
Indeed, my Lord.
Thank you.
I will locate it, and through my senior who is going to speak now, I will get that information for the benefit of the court. Obliged to you, my lords.
Yes, Mr. Mahfood.
May it please my Lord, I can't stand for more than a few minutes.
You're
Yes.
very welcome to make your submission sitting down.
Yes.
And we can hear you very clearly. Thank you.
Thank you. My lords, money laundering is evil and must be confronted vigorously. It is my submission, however, that this confrontation must not disrupt the role that attorneys have played in our society for hundreds of years, which role is now enshrined in our charter. What is of great importance, my lords, is to understand the role that attorneys have played and are still playing under our charter. And in order to demonstrate that, my lord, there is an excellent observation by Judge Lars B. Larson in a foreword to the IBA statement in defense of the principle of lawyer-client confidentiality. And if you look at page 7139, my lord, you will see the observation of Judge Lars B. Larson, starting with the words, "The right to independent and confidential legal advice is a fundamental principle in any free and democratic society, and closely linked to the right to a fair trial and the rule of law. At its most simple, the main beneficiary of the principle is the client who may be under investigation or prosecution by the state. it is the client who would suffer from a breach of confidentiality between him or her and the client's lawyer. Yet, confidentiality is also a principle that helps to protect the very independence of the legal profession.
Mr. I'm not sure we've got the right page reference.
No, the page you have given us is
7139.
7140, I think.
Ah.
Halfway down.
Yeah, they were trying to locate.
Oh, I'm sorry, sir.
Right, that's fine. Yep.
Have you found it, sir?
Thank you.
Yes, thank you. That's from, yes, I've got it, yeah.
Now, I pause here to observe that the right to a fair trial and the rule of law are fundamental features of democracy. And I submit that because of the role of lawyers in those features, what this case is about, in my respectful submission, it's a preservation of democracy in Jamaica. And I continue to read, my Lord, the lawyer-client confidentiality is a fundamental principle, does not preclude the fact that carefully limited and well-balanced exceptions to it may be justified. This document demonstrates how both national legislation and the courts have struck this balance in different legal orders belonging to different legal traditions. Whether such balance are the outcome of delicate legislative work or carefully considered judicial developments, these many differences and nuances should not us lose sight of the core importance of the fundamental principle of lawyer-client confidentiality. And I will draw your attention to the fact in a little while that this legislation has erased the principle of lawyer-client confidentiality. The policy is to protect privilege. The policy is to protect privilege. We say the policy is inadequate to protect privilege. But at the same time, the policy is not to protect the fundamental principle of confidentiality. And that is so important, my Lord, as I will try to demonstrate, because without the principle of confidentiality, a lawyer is not a lawyer. If you erase the principle of confidentiality, a lawyer ceases to fulfill the role of being an attorney, and he's just an agent. And what this legislation does is not only to erase the principle of confidentiality, but to erase the role of attorneys in our society. And if I may just draw your attention to the observation of Lord Newberger. He's at page 7139. It's the last 3 paragraphs of his comments, Lord Newberger. And he said, starting with the last 3 paragraphs, why does lawyer-client confidentiality matter? Why does lawyer-client confidentiality matter? In a free and democratic society, it is essential that everyone has access to independent and confidential legal advice, whether in connection with a private dispute, a dispute with government, a family dispute, or a criminal dispute. A vital component of the right to legal advice and legal representation is that communications between lawyers and their clients remain confidential. Such confidentiality is a client's right. It is a shield that protects citizens' rights of access to an independent lawyer, in that it ensures that clients and their lawyers are able to communicate so that lawyers can act for and advise their clients in the client's best interest. It is not right for governments to start deciding on the extent or nature of the privilege to be enjoyed in any particular case. It is for the courts to enforce the well-established principle of legal privilege against attacks from all comers, including but not limited to governments. The International Bar Association is to be congratulated for explaining and justifying the importance of the principle of lawyer-client confidentiality in this document. I strongly encourage everyone interested in the rule of law, and even more so, anyone contemplating changing the law on legal privilege, to read this document.
So he's talking about confidentiality in the sense of legal privilege, isn't he? He's talking about confidentiality
Yes, sir.
in the sense of legal privilege.
Yes.
Yes.
Well, lads, it is my submission that the regime failed to follow the standard of not interfering without carefully limited rules. In my submission, there are 3 areas in which the rights of attorneys have been infringed without justification. 3 separate areas. The first is the fiduciary duty of confidentiality. The second is privilege. And the third is regulated attorneys at law and their clients' constitutional right to liberty and security of the person and privacy. Now, my Lord, I will address the court on the first 2, that is confidentiality and privilege, and my learned colleague, Mrs. Georgia Gibson Henley, will address the court on the third. Now, Lord, I will start off by referring briefly to the burden of proof. And I do that, my Lord, mainly because the appellants are relying on the presumption of constitutionality and or legality, as the full court did. And the full court did it. And what the Court of Appeal did was to point out that they were wrong in doing that. And the Court of Appeal's criticism of the full court is at paragraph 102, 389 of the bundle, 111, 393, and 112, 394. In other words, the Court of Appeal criticized the full court for doing exactly what counsel for the appellants have done, to rely on constitutionality and privilege. My Lord, the Attorney General relied on the seminal case of Hines and the Queen and cited a lot of other cases following Hines. And there is no doubt, my lords, that Hines was a seminal case cited over and over again. What they failed to point out is that Hines was decided under a different constitution and is totally inapplicable to the Charter. And Lord, I remember Hines very well, because when I addressed Lord Diplock, I was standing. But
You're a very lucky man. I never had that privilege.
My submission, my Lord, that under the Charter, in determining the question of constitutionality, there is no room for the application of any presumption for a very simple reason. It has been clearly established that under the Charter, the complainant has the burden of proving a breach. Having discharged that burden, the burden shifts to the state to prove justification. In discharging that burden, the state cannot rely on any presumption. There is no room for the application of a presumption. The state must discharge the burden of proof. And, Lord, that matter is put very clearly and very lucidly by Chief Justice Sykes in a case in Jamaica, Julian Robinson. And Chief Justice Sykes put that very lucidly. And may I refer you, sir, to my written submission, all written submission at page 6198. 6198. And no, we soon come to that.
That's it.
Well, because I'm leading up to Julian Robinson, but I'm starting just a paragraph earlier.
Well, 6198 at any rate.
6198.
In my bundle is Oaks.
I start off with a submission, and then I refer to Oaks. So, starting with my submission at 6198, the submission is...
Mr. Mahfood, your submission, I think, isn't on page. What we've got on 6198 is Oaks itself.
I think it's paragraph 13 of the case,
page 1973.
My paragraph 12, first of all, is 6198. Paragraph 13, I cite Oaks at 6200. and then Julian Robinson at 4771.
Yeah.
So if, with your permission, my lord, I'll start with paragraphs to 6198. It is submitted that the correct approach to be adopted in treating with section 13.2 of the Charter of Rights is, firstly, the applicant has to demonstrate that a prima facie interference with a Part 3 right has occurred. He or she who alleges has a burden of proving, while at the second stage, the onus shifts to the state to demonstrably justify the limits Parliament has placed on the right of freedom. Now, in R.B. Oakes, my lord, at 6200, R.B. Oakes, 6200, Chief Justice Dixon, in treating with the meaning and effect of Section 1 of the Canadian Charter, stated at page 105, that is 6200. Section 1 of the Charter has two functions. First, it guarantees the rights and freedoms set out in the provisions which follow it. And second, it states explicitly the exclusive justification criteria outside of Section 3 of the Constitution Act, against which limitations on those rights and freedoms may be measured. And we have the same formula, my lord. The onus of proving that a limitation on any charter right is reasonable and demonstrably justified in a free and democratic society rests upon the party seeking to uphold the limitation. Limits on constitutionally guaranteed rights are clearly exceptions to the general guarantee. The presumption is that charter rights are guaranteed unless the party invoking Section 1 can bring itself within the exceptional criteria justifying their being limited. Now, Lord, I move on to Julian Robinson and Chief Justice Sykes. That is at 4771 to 4772 of the bundle.
I don't understand this to be in dispute. I mean, you say in paragraph 17 the full court adopted this approach. There was no appeal against this finding. I don't understand this point to be in dispute. Am I wrong?
Yes, my lord, but I am only emphasizing that to deal with the inapplicability of a presumption of constitutionality. And what is undisputed establishes that there is no presumption, there is no room for a presumption.
In relation to justification?
Yes.
Yes.
And that is my point, my lord.
Yes.
And I cite Chief Justice Sykes at page 4771 to 2, paragraph 99 of Sykes. The effect of the presumption in favor of guaranteed rights and freedoms is that once a claimant makes a case of violation, the burden evidentially and legally shifts to the one seeking to uphold the violation. Where the burden is not discharged, the claimant must succeed at the end of the case. This also means that if the claimant makes a case of violation and the violator responds, but the adjudicator concludes that the response of the violator leaves the scales evenly balanced, the claimant must succeed because of the presumption in favor of fundamental rights and freedoms. The claimant, having discharged his burden, and if the violator fails to convince the court that the violation is justifiable in a free and democratic society, then it must mean that the law is unconstitutional. Any other conclusion would be irrational and contrary to reason. the presumption of constitutionality cannot assist the violator if a prima facie case of violation is established. Violation must be justified. And I cite this case to support my submission that the appellants are wrong in relying on any presumption of constitutionality or legality.
It's your submission that that presumption of constitutionality or legality has no role to play at any point of the analysis.
That's right, sir. That is my submission. And that is a view of laws, of Sykes. And the reasoning is simple. There is no room for a presumption. The state has to prove justification. At that point, they can't rely on any presumption. They must prove justification. Therefore, my point is that the presumption of constitutionality has no place in the exercise.
Well, where there is a violation of a guaranteed right.
Yes. Yes, my lord.
You're not putting it wider than that, as I understand it. You're simply saying the presumption of constitutionality, whatever other role it may play, is spent once it's shown that there's a violation of a guaranteed right.
Correct, my lord.
Yes.
That's my I respectfully agree, sir.
But is it relevant in deciding whether or not there is a violation of the right?
No.
If one's first got to decide whether there's a violation of the right,
no, because
has the presumption of legality got any role to play in deciding that question?
In my submission, no, sir. Because we cannot be relieved of the obligation to prove a violation by relying on a presumption. And
so you are making the extreme argument that the presumption of legality or constitutionality has no role to play at all in any part of the analysis.
That is my submission.
Well, I don't think that's what Chief Justice Brian Sykes is saying in Julian Robinson. It's rather being said that once one's got through the violation stage, then the presumption of legality may have no role to play, as I understand it.
Yeah, well, I respectfully agree. And I adopt the approach of Chief Justice Sykes. And I accept your Lordship's point that it may be relevant at the first stage. But my main point is that the state is not relieved of the burden of proving justification.
Right. Well, if that is the submission, I'm not sure there's much dispute between the parties. I think the dispute is whether it's got any role to play.
Well, that is my prima facie. That's my first submission.
Barrier should be placed when the charge is wrong. No, barrier should be placed in front of the citizen when they are seeking to vindicate.
But my submission also is that in discharging the burden of proof, the citizen shall not be blocked by any presumption. So I respectfully submit it has no place in either discharging the burden of proving a breach or in proving justification. Now, my lords, I now move on to deal with the first substantive point I'm dealing with, the fiduciary duty of confidentiality. And it is a critical point because it is clear beyond doubt that the fiduciary duty of confidentiality is of fundamental importance to the work of attorneys. And I submit it is almost common ground, and it has never been suggested otherwise. It is almost common ground that this has not received any protection, and the policy was to give no protection. And then that is why the appellants now try to justify it by talking about proportionality. But before you get to proportionality, you have to have some test, and you must have adequate protection. You cannot get beyond the point of adequate protection by talking about proportionality. And that is an extent of their desperation. They can't find any protection. They can't dispute that it is left unprotected and erased, and then they now talk about proportionality. Now, my Lord, may I refer you.
Just to be clear, here we are talking about those aspects of confidentiality which lie outside privilege, I think.
Oh, yes, my Lord. In my respectful submission, constitutionality is an independent principle existing independent of privilege. And for that, the result of that, my Lord, is when the legislation allows the attorney to hold back privileged documents. That does not authorize the attorney to hold back documents that are not privileged. His power is to hold back privileged documents, and therefore confidential documents will have to be released. Now, may I refer to our written submissions? On the starting at paragraph dealing with the fiduciary duty of confidentiality, and that's at 7134, my Lord, 7134. The fiduciary duty of confidentiality. The duty of my submission is the duty of confidentiality arises out of the fiduciary duties owed by the attorney to the client, which are generally viewed as twofold: loyalty and confidentiality. Like the attorney-client privilege, the duty of confidentiality serves the purpose of contributing to the trust that is the hallmark of the attorney-client relationship, whereby the client is able to communicate fully and frankly without the threat of the legally damaging, embarrassing, or secret information being shared with others. It is fundamental. Once a citizen loses confidence in the fact that anything he says to his attorney is kept confidential, it is impossible for the citizen to speak frankly to the attorney. And it destroys the relationship of attorney and client.
Mr. Mahfood, in the civil procedure rules of Jamaica, with which I regret I am not as familiar as perhaps I should be, where a party to civil litigation is required to give disclosure of documents, he can resist disclosure on the grounds of privilege, as I understand it, at least in the English rules, but not on the grounds of confidentiality.
Yes, ma'am.
Is that also true in Jamaica?
Yes.
Because that would appear to be a quite substantial inroad into attorney-client confidentiality in relation to material which is not privileged.
Precisely, well, that's my point. That is my point. The duty of confidentiality is independent of privilege.
Yes.
And the policy of this legislation was to protect privilege, which we say is inadequate, but not to protect confidentiality. And the response of the attorneys for the appellants is to say it is justified on the ground of proportionality. They are not saying that it is protected. They concede that it's not protected, but they talk about proportionality. If I may go on to my paragraph 25, my lord, which is at your record 7027 to 7033. 7027 to 7033, which is an article on legal ethics, an article on legal ethics by Mark Ellis, which is exhibited. And that's at 7027 to 7033. And I now summarize what Mark Ellis says. My paragraph 25, which is 7027, is 7033. The duty of confidentiality is broader than the attorney-client privilege. It is not subject to the same exceptions. It includes, but its assertion is not limited to, information passed directly to the lawyer by the client. It is not limited to legal advice or communications related simply to legal matters. The duty also applies to communications with only potential clients. The duty survives the termination of the attorney-client relationship and even the client's death. And I cite an article by Mark Ellis. And I go on, my lord, at paragraph 26, is at 3843 of your bundle. 3843, the case of Descoteau versus Mietzwinski. Paragraph 384. The substantive right of a client to confidentiality in respect of his communication with his attorney at law may be raised in any circumstances where such communications are likely to be disclosed without the client's consent. And I cite Descoteau. Where no provision is made to protect this substantive right, which has been elevated to a constitutional right, being a component of the right to privacy, the court must be extremely vigilant in safeguarding it. The making of suspicious transaction reports to the Financial Division calls for such an approach. And then I continue at paragraph 27, 2932 of your bond, 2932. There is a rebuttable presumption that all communications between clients and their attorneys at law are prima facie confidential. And I cite the Canadian case. And I submit, my lord, that is a sensible principle. A man does not go to his attorney to discuss a social event. He goes for the purpose of getting serious advice. All communications in my submission are prima facie confidential. Then, at my paragraph 28, which is 5908 of your bundle, the uniqueness of the special relationship between attorney and client was underscored in Prudential PLC and Prudential Gibraltar Limited and Special Commission of Income Tax at paragraph 51, in which the court held that the attorney-client privilege would not be extended to accountants, even in a case where accountants were giving tax advice. Now, the relevance of that is that the appellants keep talking about the same rules that apply to us, apply to accountants and other professional people. Therefore, why should we be privileged? We should be privileged because we are attorneys. And that is what this case is all about. We are not saying that these impositions should not be imposed on accountants and other non-financial people. We say they should not be imposed on attorneys because attorneys are a different breed. They are fundamental in maintaining fair trials and the rule of law. It's a unique, special position, not for the benefit of attorneys, but for the benefit of clients and for allowing attorneys to fulfill their function. And I continue, my lord, the paragraph 207-208. The full court found that the regime has interfered with the right to privacy and confidentiality and has to be justified. Therefore, that's not an issue. They never appealed against that. The full court found that the right to privacy and confidentiality has to be justified. The full court said, although the court finds that the principles of LPP have not been breached by the power given to the JLC to inspect and examine documents, it finds that insofar as an attorney is required to disclose information obtained as a result of exchange between him and his client, the regime has interfered with his right to respect for and protection of his private life and the right to protection of privacy of communications enshrined in section 13(1), 2, and 3. Whether this interference is demonstrably justified in a free and democratic society will be considered below. So this is what the full court found. There is a breach of the right to confidentiality of communication, and there's been no appeal. And that is the law of the case in my submission. And then I say, it follows that the only issue in the Court of Appeal with regard to confidentiality was the issue of justification. Then I continued your notes, my lord, at page 250 to 251. And this is important. Paragraph, your E1, 250 to 251. The full court found justification in paragraphs 364 and 365. And 364 and 365 are 250 and 251. Namely, that there were adequate safeguards against inadvertent breaches or disclosure of privileged information and was proportionate since the infringement of attorney-at-law's private rights representing minimal interference and is demonstrably justified. So what the full court found, justification in that it was minimal interference and that there were adequate safeguards, Well, my lord, I submit it is respectfully submitted that this finding is clearly erroneous, since the provisions designed to give some protection to legal professional privilege give no protection to confidentiality. Consequently, an attorney is required to produce confidential documents which are not privileged on pain of criminal prosecution and disbarment. This is horrible. And then I said paragraph 34. It is the aforesaid erroneous finding of the full court that the GLC argues to be demonstrably justified in a free and democratic society. That is what the appellants, the GLC, say in their submission in paragraph 3 of their case. And that's at 1922 of your record, 1922. The GLC say that finding is demonstrably justified, when the finding is based upon a misunderstanding of the protection. The protection applies to privileged documents, not confidential documents. And I continue, my Lord. The same may be said of the tipping off provisions, which violates a fiduciary duty which an attorney at law owes to the client, since breach of section 98(1)(b) may lead to imprisonment of up to 20 years. If he doesn't disclose confidential information in violation of 98(1)(b), he can be sent to prison for 20 years. And I continue, my Lord, that my paragraph 36, which is 2310 of your bundle. It appears that the regime purports to give some protection to LPP. This has not been achieved. Further, no protection at all is given to the fiduciary duty of confidentiality. And I say see section 104(3)(c) and 4, 108(1)(a) and 117, which refer exclusively to privilege. So the protection is to privilege, not to confidentiality. And that is, the sections are to be found at 2310, 2314, and 2327. And further than that, my Lord, that policy is consistent with the recommendation of the GLC. That was the recommendation of the GLC. And that is a statement of facts and issues at paragraph 28, at 1846. I'm looking for the statement of facts and issues.
You got it? 181.
That's at 39, paragraph 28. 1846, 1846.
1848.
Paragraph 20A is what you want. Paragraph 20A, 1846.
Look for paragraph 106. Paragraph 20A is what I'm looking for. Paragraph 20A, and it says, among the recommendations from GLC were that A, the regime should not be applied to attorneys when engaged in proceedings in court, whether civil or criminal, and its application to attorneys should be strictly limited. In other words, they're saying it is related to privilege. They're asked to protect attorneys who engage in privileged activities. So that is consistent with the policy of the legislation. And then I continue, my lord, at paragraph 38, which is 1933. And I said, this is what I submit. I'm now dealing with the case presented to you by the GLC. And I'm citing from their case in paragraphs 43, 44, and 45, and paragraph 54. And that is in your note 1933 and 1935. And I submit it was common ground in the courts below that the regime purports to protect legal professional privilege, but not the duty of confidentiality. And if you see GLC's case, paragraphs 43, 44, and 45, in which the GLC in their submissions to you submit that it had to do with privilege. And then finally, in paragraph 54 of their submissions, which is at 1935, the GLC concedes in paragraph 54 that confidentiality is not protected. They actually concede that.
Page 15 of this. Well, that's what the full court found, and there's been no, as I understand it, no appeal against that. So you're, in that respect, pushing at an open door, Mr. Mahfood. But the real question, which we hope you will help us on, is justification in this aspect of the
yes.
case.
And in paragraph...
You've taken us to the paragraphs of the full court where they conclude that it was demonstrably justified.
Yes.
And that's the point which is on which you and the appellants are divided.
Yes. Yes, my lord, we are divided.
Yes.
And in paragraph 54 of the GLC
yes,
submission is at page 1935.
Yes, thank you.
1935. Where they say, 1935, paragraph 54. So while the GLC is empowered to inspect documents that are private and possibly confidential, it is not empowered to inspect documents that are privileged. So they there concede, which is undoubted, that confidentiality is not protected. My Lord, that concludes what I have to say about confidentiality, and I now go on to legal professional privilege. And dealing with legal professional privilege as applies in Jamaica. Because Jamaica is a common law country, and the common law principles that apply in England and in other Commonwealth countries, including Canada, apply in Jamaica. And the cases I will cite establish the following principle. Legal professional privilege is a fundamental human right. Legal professional privilege is a fundamental human right with its almost absolute nature, closely linked to a fair trial and the rule of law, which are essential features of a free and democratic society. That's my submission. I submit, in Jamaica, it's a fundamental human right, almost absolute in nature, the way it is sometimes as absolute, as close to absolute as possible. Now, the cases I refer to, my Lord, cases I cite in my written submission are starting at your Lordship's bundle 6032. In Derby Magistrates Court, Ex parte B. Now, the citation of reports is wrong. It should be 1961, one appeal case is 487. And I'm citing Lord Taylor of Gosworth, observed at pages 540 and 541. 540 and 541, which is 6053 in your bundle. As for the analogy with public interest immunity, I accept that various classes of case in which relevant evidence is excluded may, as Lord Simon of Glasdale suggested, be regarded as forming part of a continuous spectrum. But it by no means follows that because a balancing exercise is called for in one case, it may also be allowed in another. Legal professional privilege and public interest immunity are as different in their origin as they are in their scope. Putting it another way, if a balancing exercise was ever required in the case of legal professional privilege, It was performed once and for all in the 16th century and has since then applied across the board in every case, irrespective of the client's individual merits. And I continued to cite the Duke of Argyll. The Duke of Argyll is 3916 and 3921 the part. And I'm citing the Duke, I'm citing Lord Reed. There is no question that legal professional privilege is a fundamental principle of the common law and one deeply embedded in our legal system. The authorities have established the almost absolute nature of the privilege. Duke of Argyll. Lord Reed noted that the effect and purpose of the law of confidentiality is to prevent from the court from asserting the truth so far as regards those matters which the law holds to be confidential. And that quotation is from 3921. Then I go on to cite Lord Hoffman in Regina versus Special Commissioner, and paragraph 43 of my written submissions, which is 5668. 5668 of your Lordship's record. Legal professional privilege is also viewed as a fundamental human right long established in the common law and as being much more than an ordinary rule of evidence, limited in its application to the facts of a particular case, but rather as a fundamental condition on which administration of justice as a whole rests. And that principle applies in Jamaica. The reference to Lord Hoffman in all England law reports is wrong. It should be 1961 Appeal Cases 487. And I continue to Morgan Grenfell at page 6522 of your bundle, 6522. Lord Hoffman in Regina versus Special Commissioners and another, expressed in these words at paragraph 39. The European Court of Human Rights has said that LPP is a fundamental human right which can be evaded only in exceptional circumstances. Exceptional circumstances. And that's interesting, my lord, because when we come to the judgment of the full court, the reasoning was because of the activities that were covered under the application to attorneys. It was only in exceptional circumstances that there was a relevant legal context, and it was therefore minimal, and it was therefore justified. Exceptional, minimal, justified. And I refer to that. The European Court of Human Rights has said that LPP is a fundamental right which can be evaded only in exceptional circumstances. See Foxley. Mr. Brennan said that the public interest in the collection of the revenue could provide the necessary justification, but I very much doubt whether this is right. Nor is it sufficient to say simply that the power is not used very often. That is no consolation to the person against whom it is used. And I rely on that, my lord. The finding that it is only in exceptional circumstances that privilege arises. And it is only in exceptional circumstances that it is not protected. But that doesn't help the citizen whose privileged information is disclosed, if you say to him, oh, you're an exception, it is not an answer to the point. That is no consolation to the person on whom it is used. If new legislation is passed, it will have to be seen whether it is limited to cases in which the interference with LPP can be shown to have a legitimate aim which is necessary in a democratic society. So now, this is my point. We're talking about a democratic society, and this is why I say over and over again, that's what this case is about, preserving Jamaican democracy. I now go on to the finding of the full court. My submission is that the critical finding of the full court on legal professional privilege is that it was only in exceptional circumstances that there was a relevant legal context when attorneys performed the activities that brought them within the regulated sector. Interference with privilege was an exceptional event. Therefore, interference was minimal and justified. May I go back, my lord, to paragraph 45 of my submissions? The critical holding of the full court was that, 1, the only activities listed in the DNFI order that will arise in a relevant legal context are in item 5. That is, creating, operating, or managing a legal person or legal arrangement, such as a trust. So what they say is the only time there's a relevant legal context is under creating a trust. 2, and I again cite the full court, it is only in rare circumstances that LPP attaches to communications in relation to transactions concerning activities captured within the order. And I refer to paragraphs 19, 120, 121 of the judgment of the full court, which concludes it is only in rare circumstances that LPP attaches, and then I refer to paragraphs 119, which is 155 of your bundle, 155, paragraph 1220, which is 155, paragraphs 121, which is 156 and 7. And 132 of the judgment of the full court. And then the full court went on in paragraph cited at 1601 on the few occasions on which LPP was breached, it was adequately safeguarded and therefore justified. So the reasoning of the full court was exceptional, minimum interference, therefore justified. My submission is that the finding of the full court is clearly erroneous and cannot be supported. I I submit, my Lord, in paragraph 47. FATF recommendation 22 required member states to regulate financial as well as some DNFIs. The DNFI order was promulgated by virtue of the powers conferred on the minister. This is common ground, my Lord. By the DNFI order, attorneys at law, as well as other specified professionals who engage in the following specified transactions are brought within the regulated sector. 1 is purchasing or selling real estate. 2 is managing money, securities, or other assets. 3, managing bank accounts or saving accounts. 4 is organizing contributions to the creation, operation, or management of company. Creating, operating, or managing a legal person. Purchasing or selling. A wide range of activities. And it is my submission, it is unreasonable to suggest that in performing this very wide range of activities, it is only in exceptional circumstances that there were a relevant legal context.
Mr. Mahfood, I asked the appellants in relation to category 4 whether organising contributions for the creation, operation or management of companies was to be understood to mean financial contributions. And I think their answer was that it should be understood in that way. Do you agree?
You asked the appellants if category 4 is in relation to financial contributions, and they said yes. He wants to know if you agree for the formation of companies on these categories. 4, what do we understand this to mean? Is it financial contributions?
I think so. Yes, my Lord.
Thank you. Thank you.
I go on to deal with the relevant legal context. I submit that the full court erred in holding that there are very few exceptions to the position that the DNFI activities listed in the order are outside of a relevant legal context. These relate to activities enumerated as part of item 5 in the order, that is, that of creating, operating, or managing a legal person or legal management, such as a trust. And that is paragraph 119 to be found at 155 of your body.
Yeah.
Mr. Mahmood, does it really matter the frequency with which the activity will attract legal professional privilege? Because I think the case being put against you is that whatever the range of circumstances, legal professional privilege is in any event protected by the regime. So simply, as I understand it, your submission here is, well, the full court may have erred in what they regarded as the range of activities attracting legal professional privilege. But let's assume you're right on that.
Well,
does that really answer the point that in any event, within those areas, legal professional privilege is properly protected by the regime?
Oh, yes, yes, my Lord. I will go on to deal with that, and I will point out that the critical question which is agreed between us and the appellants, the critical question on the question of constitutionality is whether or not privilege has been adequately protected and safeguarded. That is a critical question.
Yeah.
And I will come on to show that on that critical question, the regime did not adequately protect. And I go on to show, and that is the main burden of my argument on protection, that the Court of Appeal carefully analyzed this issue, the issue of whether or not there is adequate protection, and carefully came to the conclusion that it was not adequately protected. And I will refer you in due course to the paragraphs of the Court of Appeal where that was carefully examined by the Court of Appeal.
Yeah, I mean, that would seem to me to be the key point that you need to address, because if you look at the full court's judgment, there are passages, I mean, looking at the whole context, they tend to just say, generally, these are activities that would not attract legal professional privilege. In general, I agree there are also a few passages where it might be said that the exceptions are rare exceptions, but I don't think they actually, looked at across the whole board, can absolutely be clearly saying that. So it seems to me there's an issue about what the full court has said about the range of the activities attracting legal professional privilege. But that seems to me, at the moment, not really to be the crucial point. The crucial point is, within the areas where it does apply, is the regime protecting legal professional privilege? And I think you say you're coming on to that.
Yeah.
As far as you know, all of the paragraphs that they refer to talk about, except for 91A3, talk about privileged circumstances. Privileged circumstances and LPP are different.
Well, I would suggest, my lord, that the protection of privileged circumstances provides a defense to an attorney. And it does not provide adequate protection. It does not really deal with adequate protection. Privileged circumstances merely creates a situation where an attorney who is prosecuted, has a defense that the information came to him in privileged circumstances. But that does not deal with a critical issue. Where there are documents containing privileged information, is there machinery to ensure that they are protected? And that is the kind of issue that the Court of Appeal examined. That they say, for example, the appellant cites a case saying that the attorney can go to court. But that is not an answer to the question of adequate protection. Of course, an attorney can go to court. But the question is there a machinery in the law which ensures protection to the privileged document? And that is where the Court of Appeal analyzed the situation very carefully.
The issue was addressed in this case, earnestly. So I'm not sure the paragraphs that you reported. Just a minute. Perhaps in Jamaica, the courts play a role in formatting guidelines. Alas, the judge did not take account of the same principle.
May I refer you to Ernest Smith case, Ernest Smith, and that is in your bundle at paragraph 4633. Page 4633, electronic bundle.
Yes.
And the point there is that legal professional privilege, you cannot leave it to the attorney to provide the protection. The protection has got to be provided by some machinery in which the courts determine the issue.
Well, can I just ask you about that? If the Jamaican process of giving disclosure of documents in civil proceedings is anything like the English and Welsh process, the way in which LPP is protected in that process is that the attorney of the party giving disclosure goes through his client's files, and of course his own files held for his client, and separates out the LPP protected documents into a separate category of which he does not permit inspection. He identifies those documents in his list of documents as being privileged, and provided he does so in a sworn affidavit, that is generally speaking not to be challenged. In other words, the law of English, and I suspect also Jamaican civil procedure, is one which indeed reposes great trust in the attorney to make that judgment, and once he's made it, unless it's manifestly wrong, it will be adhered to. Now, why is it that if that's the trust that the law, the procedural law for civil procedure places in attorneys, that no similar trust can be placed in attorneys when they are considering what documents to show the regulator under this regime, or what documents or what information to rely upon for the purpose of making a suspicious transaction report?
In this context, if the law is the subject of the...
I mean, it's a very long question, and I'm perfectly content if you come back and answer it at 2 o'clock when you've had time to think about it over the short adjournment. Of course, if you want to answer it straight away, that's fine, but it is a question about which I have been concerned throughout this appeal, and I would very much welcome a considered answer from your side about it.
Don't answer it now, because we do have an answer. Don't answer it now. We'll launch an answer.
No. Yes, I'm grateful for that.
That's fine. Anyway, you were going to show us a passage in this case, presumably in Judge of Appeal Panton's judgment, which deals with this question.
On this point, my lord, it is my submission that there are many occasions on which an attorney at law, performing his professional duties within the broad range of activities described in the DNFI, will be required to give legal advice which consequently has a relevant legal context and must be adequately protected. For example, in my submission, in the course of a conveyancing transaction, frequently permissible tax-efficient structures to minimize tax exposure and related steps in the nature of estate planning require legal advice. In the course of a developer preparing to undertake a substantial real estate development, significant legal risk management and allocation are advised upon, as well as permissible tax-efficient structures to minimize tax exposure. In other words, my Lord, there are many situations in which attorneys performing the activities which bring them within the regulated sector will require them to give legal advice. It is my submission, my lords, that the Court of Appeal carefully examined and showed the inadequacy of the protection provided by the regime in many of the paragraphs of the Court of Appeal judgment. Now, there is no disagreement between my learned friend and myself that the critical test is adequate protection. Was it adequately protection? But what the appellant does, the second appellant, having stated the question, then goes off, in my submission, at a tangent and goes to great length to try to establish that the Canadian law of privilege is wider than the Jamaican law. And the appellant goes to great lengths to try and show it's wider. In my submission, that is irrelevant, because all the fundamental rights of privilege exist under Jamaican law. And the question of whether it is adequately protected is not answered by arguing that the privilege in Canada is wider. In my submission, the privilege in Jamaica is very wide. There is an interchange in the privilege law by Canadian cases and English cases. And it is a common law. And it is not correct to argue that it is adequately protected because the Jamaican court wrongly treated Canadian law as identical. And my friend even goes to the length to say that the Court of Appeal altered, changed Jamaican law of privilege. The Court of Appeal did no such thing. They were not changing the law of privilege. The Court of Appeal was examining the question of adequate protection. And in support of my statement that the common law is the same and that cases in Canada cite English cases and vice versa is the fact that Lavallee, a leading Canadian case, which is to be found at 5099, cited Anderson and the Bank of British Columbia, which is an English case. Lavallee cited an English case. And they cited Anderson, which is an English case. And then a Court of Appeal case in England cited the same case, Anderson, at page 3323. Bellabel cited Anderson, which is the same case cited by Lavallee. And the English case of Derby cited Bellabel, and that's at 6052.
Cited Anderson. All three cited Anderson as the source and origin of privilege.
And then a Jamaican case of Ernest Smith cited Derby. That's at 4676. Ernest Smith, a Jamaican Court of Appeal case, cited Derby. So there is an interchange.
So the Act, that section 94.8, summarises what the appellants say is the Jamaican law of legal professional privilege. Do you disagree with the terms in which section 94.8 summarises the principles of legal professional privilege?
Can we deal with this in a note, as part of the note?
All right.
In the paragraphs in the Court of Appeal judgment that analyzes this question, whether or not there's adequate protection, there are innumerable paragraphs, and I will just refer to a few. For example, paragraph 218, 219, 220, and 221. That's in your lordship's pages 442 and 443, starting at 218. At 218, it's at page 442. It is clear where the Court of Appeal says, page 442, it is clear, though, that apart from routine examinations, the GLC is also empowered to conduct other examinations, such as special and random examinations. Special examinations are undertaken in circumstances where the GLC has cause to be concerned about the compliance of a regulated attorney at law with the regime, or where it has reason to believe that an attorney at law is providing designated activities, but has declared otherwise in the requisite annual declaration. In terms of random examinations, there is nothing disclosed as to exactly what these will entail. The process and protocols for these examinations are not disclosed, except that prior notice will be given to inspection. no form which will be used in these examinations has been made available. And my learned friend referred to a general form. But in my submission, that general form does not mean that that is all that the court, that the JLC can you do. What they can do is not limited. And then at paragraph 442, the Court of Appeal says, the plain fact is that there is no possibility of privileged documents being passed on to the GLC during the examination to be conducted by it. There will have been no need for a strong directive from it in its guidance that documents are to be segregated from those that are not before the examination are conducted. Also, there would have been no need for the POCA itself to provide that privileged information is exempt from disclosure. There is an undeniable recognition of the possibility of disclosure of privileged documents connected to the enforcement of the regime. Then paragraph 220, which is your 443. Once a possibility exists that privileged documents could be disclosed wittingly, unwittingly, inadvertently, or otherwise, there should be adequate mechanisms in place to guard against such disclosure in protecting the client to whom it belongs, giving the value of LPP in a free and democratic society. And paragraph 221, which is your 414. The relevant provisions of the POCA, while making it clear that documents or information subject to LPP must not be disclosed, do not expressly state that an attorney at law may claim privilege on behalf of his client. However, it is implied. It is expected that any competent and well-trained attorney would seek to claim privilege on behalf of his client once he believes that a claim should be made. The POCA, however, prescribes no procedure governing the issue if a claim of privilege is made during the course of the examination.
But then why should it not be sufficient that the attorney says, I'm claiming privilege? If that's what he says on an affidavit in civil proceedings, that's the end of the matter.
Well, the reason why the Court of Appeal there says there must be some machinery.
Yes, but why?
It means that attorney may or may not do it. And the question is, there should be notice to the client, there should be, to protect the client, there should be minimum requirement, there should be notices sent out to the client. It shouldn't be left to the energy of the attorney.
It's a client privilege. It's a client privilege.
It's a client's privilege, and the machinery should protect the client. And then the Court of Appeal says, paragraph 222, 443, your note, 443. Even though the JLC is contending that the court's involvement could be sought where there is a dispute, there is nothing provided in the legislation, the regulations, or by any rule of procedure for the resolution of the issue of disclosure by judicial intervention in such circumstances. A note is made of Section 136 of POCA. It provides that rules of court may make such provision as is necessary to expedite to give effect to the regulations. Now, I know the GLC says it is because of the injunction why they haven't been able to pass those regulations. But the question is, do regulations exist? In viewing the adequacy of their regulation, it is not relevant to say what could be done by the JLC were it not for the injunction. The question is, what is the existing procedure to protect privilege?
And the injunction is about 4 or 5 months after they put the regime into effect.
And then the Court of Appeal says, paragraph 223, the absence of a specified mechanism in the POCA and the regulations aimed at governing disputes that may arise relative to disclosure and LPP within the context of the GLC's monetary function is indeed a significant lacuna in the legislature itself. To my mind, merely providing without more that documents or information subject to LPP should not be disclosed without providing an effective mechanism to ensure its protection is not going far enough. Then, paragraph 225, which is Euro 445. The Court of Appeal cites Lavallee and AG of Canada versus Federation of Law Societies, Canada versus FLC, and say both heavily relied on by the appellant, that's us, are instructive. They offer good insight into the form and level of protection that should be afforded to LPP by the regime. When it looks at those cases, a picture emerges as to how much further the legislature in Jamaica could have gone and ought to have gone to better protect LPP. Now, the GLC argue that that case is not applicable in Jamaica because the Canadian legislation gave the right to FINTRAC to enter and search an attorney's office without a warrant. They say that express power is not in the Jamaican legislation. Our submission, my lord, is that the words examine and take copies in POCA, examine and take copies in POCA, gives the power to conduct warrantless searches. And the argument in support is set out in Respondent's case at paragraph 79 to 108. Paragraph 79 to 108. And that's an area that my learned colleague will go into. And at paragraph 241, in your 453, Court of Appeal shows how Lavallee decided privilege was not adequately protected, made these observations, which I submit are perfectly applicable under Jamaican law. One, that's your 453. The provisions wrongly transfer the burden of safeguarding LPP to lawyers. Two, nothing requires notice to clients, and so a client may not be aware that his or her privilege was threatened. There is no protocol for independent legal intervention when it could not have been feasible to notify a client. A judge has no discretion to assess a claim of privilege on his own or her motion. Unless the search is of a lawyer's home office, nothing required prior judicial authorization. Examining and copying documents would have proceeded until privilege was asserted, an approach that considerably elevated the risk of breach of privilege. Claiming privilege required revealing a client's name and address, even though that information may be subject to privilege. And paragraph 242, your 450. In the light of the observations of the court and the principles enunciated in Lavallee, it may safely be concluded that the protection of LPP in our regime is far more inadequate. Indeed, there is absolutely no statutory mechanism designed by Parliament to safeguard LPP as in the Canadian regime, which was still found to be wanting. The GLC guidance has sought to fill that gap left wide open by Parliament by requiring regulated attorneys at law to segregate documents to avoid disclosure of privileged information. This is putting the burden on the attorney at law to protect LPP, which is one feature of the Canadian regime that the Canadian Supreme Court took into account in finding that LPP was not adequately protected. And may I just make an observation at this point? The appellants rely on the guidance notes. The guidance notes issued by the GLC. Our reply is that guidance notes are not law. Guidance notes are not law. Those guidance notes can be changed. Also, so far as the elaborate submission about the GLC having on it members as part of the disciplinary authority, lawyers and so forth and so on. There's nothing to prevent the minister making the designated authority the Commissioner of Police.
Competent authority. Competent authority.
The competent authority. And therefore, the fact that this particular competent authority has a certain policy may even be changed, but it is not protection, it's not adequate protection, because the minister can change the competent authority. And again, my lords, I hate to repeat myself, but what we're talking about is maintaining democracy. And democracy cannot depend on the policy of the government from time to time. Democracy exists by the rights conferred on attorneys. And those rights go to the role of attorneys. And those rights are the rights protected by the Constitution. And this shouldn't be determined by governments from time to time. We're talking about preserving Jamaican democracy. And I go to paragraph 243, which is at 454 of your bundle, 454. Similarly, there is absolutely no provision in the regime for any notice to the client to whom privilege belongs. Client information can be shared without their knowledge or consent. In Canada, at least some provision was made for notice to be given, albeit through FINTRAC. That procedure was nevertheless rejected by the Supreme Court of Canada as being unsatisfactory. In our case, no provision is made, not even an unsatisfactory one, for notification to the client. Also, as found in Canada, to have been an unacceptable state of affairs, there's no protocol in the regime for independent legal intervention in situations where it may not be proper, prudent, and feasible to inform a client.
In many of these cases, informing the client may involve tipping off. So what do you say about that?
So the lawyer is conflicted. The lawyer is conflicted.
In many of in many of these cases, informing the client is tipping off.
Because the right is the client's, who can't be heard on the question.
But informing the client is necessary to give the client an opportunity to be heard on the question. To give the client an opportunity to be heard on the question. And the client must be given an opportunity to protect himself.
But except for the tipping off cases, the attorney can inform the client that a request has been made to disclose information.
The attorney can inform the client.
And should.
I agree, my lord, but it shouldn't be left to the attorney's industry. It should be a question of a machinery to protect the client.
But sorry, I mean, I was just going to say, it is the duty of the attorney to inform his client, unless it's a tipping off case. But that's a very special set of circumstances. I mean, you're appearing for the Bar Association. Presumably the members would perform their duty to inform their client.
I agree.
But I'm trying to understand the context in which this arises. We're here concerned with two different things. One is the obligation to report suspicious transactions. But in that sort of context, that only arises if the attorney knows or believes or has reasonable grounds to know or believe that money laundering is going on, in which case it's most unlikely that the privilege is going to arise because there's no privilege in iniquity. The other situation is the routine and special and random inspections that go on by the GLC or agents of the GLC into the whole of a firm's files, or at least that part of the files which come within the 6 classes of relevant business, which happens regularly, and sometimes more often than regularly, in relation to all the firms, the papers of all the firm's clients, in relation to those 6 types of business. Now, what is the solicitor, what is the attorney to do? If he's got a routine inspection coming up in a month's time, what does he do? Write to all his clients, say, by the way, I've got an inspection coming up. I'm going to separate out the documents which I believe are privileged so that the inspector won't see them anyway, but I'm just notifying you in case I might make a mistake. I mean, what sort of machinery is going to deal with that situation?
Well, my submission is it shouldn't be left to the attorney. There should be a mechanism which
well, what sort
exists
of mechanisms?
Or judicial intervention as in the case of a warrant, because it's the judge who then decides if privilege attaches or not.
I mean, the Canadian case isn't about a routine inspection that happens once every 6 months or once a year. It's about the police coming in with a warrant to search the premises and seize the documents, which is a quite different scenario from the one with which we're concerned, as I understand the regime in Jamaica.
Well, my point, my lord, is that the power to examine and take copies amounts to a warrantless power to search, examine and take, and that's something that we have developed in our submissions. And that is the area that my colleague will deal with, that power to examine and search.
I'll defer my questions until your colleagues on her.
But it is set out at length in our written submissions, and those will be developed by my colleague. But if we ever put it all out there.
I mean, just so you understand, it's my concern is that it's one thing for the Canadian courts to say in their own context that when the police come knocking on the door with a warrant to seize and search, there ought to be some process that enables a proper examination and extraction of privileged documents to go on within a workable time frame. But I have real trouble to understand how that sort of process would work in the Jamaican, very different Jamaican context. Don't you answer, Mr. Murphy, but I'm just making it clear for your learned friend what my concern is, the assistance which I'd be seeking.
My Lord, I have finished what I have to say on that subject of adequacy, and to the extent that it falls into the realm of my colleague's arguments, she will continue the development. I now move on to justification.
Yep.
Justification, the argument starts at paragraph 12C, 126. What's the rest? The 126.
Paragraph 126.
It's in our written case, paragraph 126.
That is page 1996. Page 1996.
Okay.
1996.
1996.
Yes, thank you.
What about 127?
Same page.
And I think I cite paragraphs in my submission 126, 127, 128, 129, and 130. And paragraph 126, in seeking to address the issue of justification, the GLC introduces a new allegation in paragraph 140, which is denied, namely that JPA refused to engage in consultation about the legislation. In discussions between the parties to settle the SFI in this appeal, the JBA made it clear that this allegation was denied. In incorporating the same allegation in its case, the GLC merely attempts to prejudice the GBA. The GLC knows there is affidavit evidence to the contrary, and the affidavit evidence is at pages 1253 to 1267. As I say, they tried to get us to agree to this as an agreed fact. We refused to agree, and now they put it in their submissions. At 125, the GLC's submission that the Court of Appeal failed to give sufficient deference to the finding of the full court ignores the fact that the area of justification involves the application of legal principles well established by the courts. And that is also my answer to the many cases that my learned friend cited on interpretation. It has never been an issue in the courts below that the problem was interpretation. That is an irrelevant argument. The issue has always been the application of legal principles under the Oaks. Both courts below applied the principle, and the question of whether they have applied it correctly. And I've argued, for example, that it has not been applied correctly in the case of confidentiality because it's totally unprotected. And therefore, there's no interpretation of statutes. So all those cases really don't have anything to do with the case. Until this moment, the question has always been application of legal principles which the courts have developed. Both the full court and the Court of Appeal applied the Oaks test in treating with the issue of justification with very different results. The Court of Appeal adopted the less stringent form of the Oaks test, namely that the law must infringe the right as least as is reasonably possible. To be constitutional, the regime must be reasonable and proportionate. To be so, the measure designed to achieve the objective must be carefully designed and not be arbitrary, unfair, or based on irrational consideration. They should limit the right that is engaged as minimally as reasonable possible. And that brings in the question of adequate protection and safeguard. This has been emphasized by Lord Newburgh, which I cited. In Julian Robinson, and this is cited as 4961 to 4962. Julian Robinson, a decision of the full court. Chief Justice Sykes. In Julian Robinson, at paragraphs 248 to 252, the full court came to the following conclusion on the test of constitutionality of legislation. Proportionality is a test for constitutionality of legislation. The Oakes test is a test to be applied. Privacy under the Charter includes bodily privacy, information privacy, and privy of notice. And then the full court goes into an area that my friend will develop, privacy. And I said the test at my paragraph 133, therefore the test of proportionality must be applied to 3 breaches. The breach of the fiduciary duty of confidentiality. My submission is that it has been demonstrated above that Parliament did nothing to protect or safeguard the attorney's fiduciary duty of confidentiality, which is a fundamental human right and the foundation of the relationship of attorney at law and client. It has been shown that this was pursuant to a parliamentary policy to give some protection to legal professional privilege, but no protection at all to the fiduciary duty of confidentiality. By giving no protection to the fiduciary duty of confidentiality, that duty has been erased from our society. That is untenable and cannot be justified. By erasing the duty of confidentiality, they have erased the role of attorneys in our society. I can only believe that when Parliament passes legislation, they did not know what they were doing. I go on to deal with the Suraj case at page 6641. Suraj and 4 others, the Privy Council case. This concerned the constitutionality of a law passed by Parliament of the Republic of Trinidad and Tobago. The board held that although the Bail Act was passed with a 3/4 majority of both houses of Parliament, under special procedure of Section 13 of the Constitution, which imposed a heavy burden on the respondent to show that the Bail Act was not reasonably justified in a society that has a proper respect for the freedoms of the individual. The Act was unconstitutional. In other words, even though in Trinidad, the provision in the Bail Act which said that bail was not granted in certain circumstances, that was also such fundamental importance that it could not be justified. In my submission, in coming to the conclusion, the board held that A, very severe consequences flowed from the infringement of the fundamental rights and freedoms of the bail provision, including the undermining of the rule of law. And B, bearing in mind that less intrusive measures could have been used. Nevertheless, in all the circumstances of the present case, the interest of the community as expressed through the will of Parliament is outweighed by the very severe consequences of the imposition of a blanket prohibition of bail. And that paragraph is in 6640 to 6641. And my submission is this, my Lord. It is submitted that the infringement of the duty of confidentiality and attorney-client privilege by the regime undermines the right to a fair trial and the rule of law to the same extent, if not more, and it's clearly unconstitutional.
A lot turns, does it not, on the reasoning of the Court of Appeal that less intrusive measures could have been adopted. But I'm not sure that the Court of Appeal specifies precisely what that means or what they had in mind. I mean, are you able to give us an indication as to what those less intrusive means would have been?
I think the Court of Appeal did indicate, if I can find the reference mark. May I refer? Here?
564 on page 577.
Starting at page 577 of your bundle, paragraph 564, 565, and continuing. Starting at 564. Starting at 564. The evidence adduced by the first respondent on behalf of the government, unfortunately, has not gone far enough to satisfy this aspect of the proportionality test. The evidence of Mr. Stevens is that over a 6-year period, the FID has received reports of over 200 suspicious transaction reports pertaining to attorneys at law in Jamaica, with results in 2 arrests and investigation of others. There is no reported conviction. What the evidence has not established is that there is no other equally dissuasive and reasonable measure that is available to the government to achieve the objective. And 5.6, I have Mr. Wood on behalf of the GLC.
Well, sorry, I didn't mean you to have to read all this out. If you can just give me the references that you say indicate the Court of Appeal's less intrusive measures. I mean, we're talking about 566.
567 to 567. 564 to 567.
Thank you.
I think it suggested there could have been a regulatory regime
Yes.
rather than one involving criminal sanctions.
Or in particular self-regulatory regime.
Okay, I'm sorry.
Yes, thank you very much.
I'm sorry. The reference is page 578, 579.
Thank you.
577 to 579.
577 to 579. And then just to continue my comments on the breach of legal professional privilege, whether or not the breaches are justified. The legal authorities are clear. The attorney-client privilege must remain as close to absolute as possible. The full court failed to appreciate the extent to which the regime infringed attorney-client privilege. It has been demonstrated above that the protection and safeguards given to legal professional privilege were not adequate and lacked many features that could and should have been part of the regulation and regulations. It is imperative that the provisions for the protection of LPP, a fundamental human right, should be found in the principal statutory framework of POCO itself, and not only in the guidelines to be formulated by a competent authority or through the devices of the regulated attorney at law themselves. The POCO itself must provide a concrete, clear, definitive, consistent, effective and fair mechanism for the protection of LPP. This absence of statutory mechanism to safeguard LPP is wholly unacceptable given its immense and indispensable value in a...
That's all right, please continue.
In a free and democratic society. Consequently, it has not been shown that the protection and safeguards of LPP are justified in a free and democratic society.
I think you've timed your submissions to perfection, Mr. Mahfood, because the next bit's going to be your is going to come from Ms. Henlin, isn't it? Henlin, yes.
Could I just say, when we do resume, could you please refer us to the passages in the Smith case that we were going to be taken to?
Yes.
Thank you.
Well, we'll resume at 2 o'clock.